one.
All right. So it's Senate Government Operations. It is Thursday, March 18th. And we are, pardon me, this week, our timing is a little bit flexible because of being on the floor. We're not sure when we're on the floor and when we need to get into committee. So appreciate people being patient with that. So we are today going to look at the Barrytown charter change and the Montpelier charter change and S-151, which has to do with mausoleums. So Tucker, are you all with us for all three?
I am with you for all three.
Great. It's nice to have you with us.
It's nice to be back.
So Tucker, would you like to help us understand the Barry charter change?
Absolutely. You have in front of you H-127, which is the approval of the amendments for Barrytown. There are 4 components of the bill. The bill is not organized in order of those components, so it's going to be a bit of a scattered walkthrough, but I'll cover the 4 areas generally and then take you through the bill.
Okay.
First, they are proposing to allow the Board of Civil Authority to designate a registered voter to act as the presiding elections official if the clerk and assistant clerk are absent on the day of that election. Second, they are proposing to split the current office of clerk treasurer into separate offices for the clerk and treasurer, making the treasurer an appointed position. Third, they are proposing to allow for the adoption of a personnel policy by the select board. Currently under their charter, personnel policies are proposed by the town manager and adopted through an ordinance. This process obviously takes a long time because of ordinance adoption laws. So they're proposing to just allow the select board to update the policy as a resolution. Finally, they are removing references to the office of lister in the charter and instead creating appointed positions for the assessor and treasurer that will encompass the lister's duties. So in order of the amendments you see in front of you, Section 4 is amended again to allow the BCA to designate a registered voter to act as the presiding election official in the absence of the clerk and assistant clerk. On page 2, there are conforming amendments for the larger categorical change I described of splitting the office of clerk and treasurer into 2 separate offices. So this changes the references to clerk treasurer in the elected offices section to just the clerk. Section 11 is amended to allow the select board to adopt the personnel policy as previously discussed. Here it states that they shall amend the policy from time to time as is deemed necessary or advisable. Section 16 is amended again to separate the duties of the elected clerk from the appointed treasurer. You'll notice that the amendments in this section are deleting duties of that office that relate to the treasurer. In section 25, we have a conforming amendment that removes the reference to the town manager's duty to propose the personnel policy that will then be adopted by ordinance. So that's struck. Section 27, this is a conforming amendment, again, splitting the office of clerk and treasurer. Section 34 and the beginning of 38, you'll notice that reference to the listers for purposes of the Board of Abatement, which currently consists of the BCA and the listers, is now going to be the BCA, the treasurer, and the assessor. And in section 38, you'll note that the town is proposing to appoint an assessor who may be hired or contracted upon terms that the select board deems reasonable. And then further on in subdivision 6, that they may appoint a treasurer and any assistant treasurers shall be deemed necessary There's language about acceptance of the office conditioned on the issuance of a bond. This is somewhat standard language for appointed officers. And all of the duties of the treasurer that are listed in subdivision A through F are comprised of current duties assigned to the clerk treasurer, again, being split off here to the treasurer. And section 39 at the end of the bill eliminates first a reference to the listers, who will be replaced by the assessor and the treasurer, and finally to the eliminating the reference to the office of the clerk treasurer, which will no longer exist and be split off. Those are the proposals from Barry.
Thank you. Senator Collmore?
Thank you, Madam Chair. If you could go back to page 6 at the top, the treasurer shall give a bond condition for faithful performance. That sounds like sort of a personal guarantee. Is that what I'm inferring from that?
This is a very strange, and I don't know if it's antiquated part of municipal officers, but historically, the municipality will issue a bond that has to be signed by the officer as part of their oath of office.
Okay.
I'm
Somebody-
not sure about any of the details beyond that
Yeah.
of what's required of the officer, but
Somebody could probably ask, should I wind up reporting the bill, what in the heck that means, and I'd at least like to have some sort of an answer.
My
I
guess
can-
is that Karen Horn can probably give you an answer to that.
And I can ask Rob Leclerc when he comes in what the committee vote was and the floor vote and all that.
So,
And-
pardon me for saying this, but I have to say this. Are these not issues that the town ought to be able to decide without our permission? I mean, really? We are such paternalistic. Anyway. My parents didn't make me get approval for things like this.
Mine made me get a bond.
Huh?
Mine made me get a bond.
Really?
All
So
right,
Tucker,
Yeah.
like the very first part about the assistant town clerk or somebody else presiding, that's over election day, not over town meeting, right? It's over the actual election.
correct. They are the elections officials when the BCA is presiding over an election in the town.
I think that given the pandemic, that was probably a wise thing to put in there. Because you could have 2 sick people on election day. Any questions for Tucker on that one? We'll get the vote from Rob. I also sent him a note and said if he could join us today, we could probably just vote it out. So Montpelier. And do
All
you,
right.
Gail, did you tell John Odom was going to join us, right?
Yeah, but we don't have that scheduled until 2:30.
Oh. Oh dear. Well, let's walk through it now and then he can come in and tell us to make good use of Tucker's
I'll
time.
send him an email.
Yeah, and if you send the 151 people an email and tell them we're way ahead of ourselves.
Okay. The only person I have for that is Representative Leclerc.
Okay. Yes,
Madam Chair,
yes.
I would suggest this charter of the town of Barry is a good example of the list we should start on the municipal bill that we're considering putting together. That the issues, some of the issues raised in it are precisely some of the things that I think you were talking about earlier when we were talking.
Yeah. And I don't know if this is in their charter, so I don't know if it's in general law. The only things that we'd be looking at is in general law, not those things that already exist in charters.
But my point
Right.
is what your comments just now
Yeah.
remind us that these are the, if we exempt them for other, it would be, I mean, these are good examples, I think, of the level of that could and should be decided without having to come to the legislature.
Yep.
But Jeanette,
Yes.
I mean, I kind of agree with what Allison was saying, but you're saying that they're asking for a charter change because these things are part of their charter. If they didn't have
Right.
a charter, it might have been just okay for them to do it on their own.
If,
That's
if
what you're saying, right?
the the difference between what I was talking about in terms of getting a list from municipalities deals with general law. Like our general law says that, because if you don't have a charter, you're regulated by general law. And
Right.
our general law, for example, says that you can have 3 select board members unless you vote to have 5. And if you have 5, you have to have 1 3-year term, 2 1-year terms, 1 2-year term. They have, I mean, that level of stuff is ridiculous, but it's in general law. If
Right.
somebody, and we can change the general law here and just allow people to do that. But if they already have a charter and it says in their charter, we're going to have 5 select board members or 10 or whatever it says in their charter, then that's going to be a separate issue that we're going to have to deal with about how to deal with charters.
So I don't want to take us down a tangent.
No,
really,
that's okay.
Waste a lot of time, but given what you just said, I mean, I've thought this before, like, why would a town want to have a charter? What's the point of having a charter?
The point of having a charter is because you can do things that aren't allowed for you to do in general law.
Okay,
General
so
law
charter,
says you can have 3 select board members. What if a town wants 4? They can't.
so your charter
they're not
allows you
allowed
to do
have
whatever you
4.
want.
So you write a charter so that you can have 4 select board members.
Okay,
Yeah.
all right, thank
Or
you.
whatever else. But we
Right.
could, at the same time that we exempt certain things in general law, we could also say for towns with charters that are wanting to make changes in these areas, we could just go ahead and make them.
Yeah.
Yeah, that's what
well,
I thought. That's what I thought too.
There are,
Without really knowing, that's kind of just what I thought.
but I think that
Tucker's
if a
gonna-
town has already adopted a charter, I think we have to be really careful about telling them how to change their charter. For example, the humongous, like 90-page bill that came to us 2 years ago that Tucker had to work on, it changed everything from it was gender neutral and it was something else, and those are town issues. So if a town has a charter and they say we need to be very careful about how we deal with the charters. We can do it, but it's a little different process.
Okay.
Does that make you less anxious, Tucker? You looked very anxious.
I was not anxious. I was just going to raise something that the General Assembly did last biennium when you were eliminating the elected office of grand juror.
Right.
One of the things that I brought up when that bill was starting in the House was that perhaps the committee should reach out to all of the chartered towns that have grand jurors in their charter and ask, do you still want your office of grand juror? Because we're about to get rid of it generally, but it's still in your charter. So please get back to us if you don't want this office anymore, because otherwise you'll have to go through the charter amendment process. And that is something that the General Assembly could start doing consistently when you're granting authority in general law or changing governance models under general laws. You could go through the charters and see, for example, the town of Barry still has required election of a clerk treasurer. We're allowing under general law the appointment of a treasurer. Do they want to have an appointed treasurer?
Mhm.
And incorporate that into the work you're doing in general law.
But we'd
Something-
have to contact all those people with anything in their charter. We'd have to.
which is what I did with the grand juror piece.
And
It was a little time.
How did you fare? What was the
think-
response?
From what I recall, every single chartered municipality opted to have their elected grand jurors struck from their list of elected officers,
Right.
including the Morrisville Electric District or something like that. So
Great. Thank you.
Yeah,
for-
I'm not saying it's impossible to do, but if we have a list of 20 things, that means going through every charter for each of those 20 things. So we need to make sure that we use Tucker's time wisely here, because that means him going to through all the charters and contacting all those towns.
Well, we gave him club membership to the 251
It's true.
on his 251 club.
Yeah,
I mean, it gives him a reason to go to some of these places.
he can't.
He can by the time we pass this law.
Okay, so let's see. Should we jump to the Montpelier? Oh, and I see John Odom just joined us also. So Tucker, would you like to walk us through Montpelier, and then John, you can weigh in?
H-177 contains one charter amendment proposal from the city of Montpelier. All of this is new, and all of it relates to the eligibility of non-citizen voters in local elections. The charter proposal includes new language for subchapter 15 governing the city voter checklist. Section 1501 is added to notwithstand 17 VSA section 2121 subdivision A1, which provides the qualifications for voters statewide. Notwithstanding those qualifications, any person may register to vote in Montpelier city elections who on election day is a legal resident of the United States, which is defined later on, and we will cover that, provided that the person otherwise meets the qualifications of 17 VSA chapter 43. So the voter qualifications still govern, with the exception that a person who is a legal resident of the United States may vote. That excludes larger categories of citizenship. Subsection B goes on to state that a non-citizen voter shall not be eligible to vote on any state or federal candidate or question. So again, this is strictly city elections and issues. Section 1502 provides new language for the city voter checklist and the duties of the clerk. It states that the city clerk shall maintain a city checklist composed of voters that are eligible to vote in city elections, and shall keep this checklist separate from any other voter checklist. So separate from the checklist for state and general elections. The city clerk shall develop necessary forms and procedures to implement this subchapter overall. So a lot of duties for John. Section 1503 is added to clarify the ballots and how they shall be prepared for city elections. In any election involving a federal, state, county, special district, or school district office or question, and a city question or city office, the clerk shall prepare a ballot that contains only the city questions and candidates, except for justices of the peace. By way of explanation, JPs elected at the local level, but are constitutional officers. So you need to meet the constitutional standards for voting to vote for them. So some clarity around this. This is when there are overlapping elections held at the local level, only city matters will be on the city ballot, and then the state, federal, school district, and special district issues will be on a separate ballot for those that are on the statewide voter checklist. Section 1504 defines two terms for purposes of this subchapter. First, it defines a legal resident of the United States as any non-citizen who resides in the United States on a permanent or indefinite basis in compliance with federal immigration laws. Second, it defines a non-citizen voter as any voter who registers and qualifies to vote in city elections under section 1501 of this charter, but is not a citizen of the United States. That is the Montpelier Charter Amendment in front of you. Happy to answer any questions.
So, Senator Clarkson.
I feel that this is exactly the same as what we had before. Is this the same charter pretty much verbatim that charter change we were asked to weigh in on last year?
Yes.
Yes.
So are there any technical questions for Tucker?
Well, I think a question that people ask is, what do you mean by permanent or indefinite basis in compliance with federal immigration laws? I know we've talked about this a year ago, but we'd have to talk that through again, because I'm sure that I would imagine that that's the question that's going to come up is, how do you define who is who? You know, do I have a driver's license? Do I pay rent? I mean, that kind of stuff. I mean, how do you decide who's permanent?
So the standard here is just that however you are legally residing in the United States is going to qualify you for election, provided that you're a resident of the city of Montpelier. That could be anything from green card to some other work visa, so long as you are complying with federal immigration laws and you are permitted by the United States to be a resident of the United States, then you will be competent to vote, qualified to vote in the local election.
Would that cover student visas?
Provided that there is legal residence under the laws of the United States, yes.
NH2, whatever the people are that work at Mount Snow in the wintertime?
That would be the triggering clause there, Senator White, would be on a permanent or indefinite basis
Right.
Indefinite.
rather than temporary.
They're on a special temporary visa.
Well, I know, I just didn't know what indefinite meant. If it meant until we say you can't anymore, because it doesn't, it says indefinite.
Right. It's a person who has a green card, who is married to somebody, as we heard last year, who lives here indefinitely and is married to that person indefinitely.
They don't have to be married to someone.
I know, but I'm thinking of my father,
Yeah, I know.
my English father, who was here on a green card until he became a citizen. But
Yeah, we you just froze Senator Clarkson, but I think that
quite the pose.
my question is, what does indefinite mean? I know what permanent means, but I don't know what indefinite means. And I think that that is a question that will be asked, and we need to have an answer to it, because we have a lot of people who work at Mount Snow, for example, not this year, but normally, who are on visas. And I don't know if it says they're there for 60 days or 90 days or 120 days, or if it's an indefinite period of time for that particular season. I don't, and I think that's what I'm trying to get at.
I think, Madam Chair, they are here for a definite period of time, not an indefinite period of time.
Okay, I don't know that. That's why, but I think we need to have the answer to that. If we're going to present this on the floor, whoever presents this needs to be clear of what it means, who is covered and who isn't covered. So that's all. I think that's what you were getting at, weren't you, Senator Polina?
Yes, definitely, yes. I think we could also learn a bit. I don't know whether John is aware of this or not, John Odom, but I presume some of this stuff came up on the House floor, and that might, if we talk to whoever reported it on the House floor, we might be able to get some ideas to where the questions went.
Yeah.
I'm not
All
sure.
right, so
I don't know whether it was Mary Hooper or Warren Kitzmiller. I'm not sure who presented it.
I'm not sure.
No, they're not in
Tucker?
GovOps. Tucker, do you know?
Probably Jim Harrison.
John Gannon,
Oh, John Gannon.
Representative Gannon, presented this on the floor. I do want to note something that I just noticed about this that might be a bit of an issue, and it's amazing that we didn't flag this before when Betsy and I were working on this, but subsection A in 1501 states that any person may register to vote in Montpelier city elections who on election day is a legal resident of the United States. And then the definition of legal resident of the United States states any non-citizen who resides in the United States on a permanent or indefinite basis in compliance with federal immigration laws. That definition would purport to exclude citizens of the United States.
Right.
So I think there needs to be a clarifying clause either in that subsection A that says who on election day is a citizen of the United States or a legal resident of the United States.
And how about a legal resident of Montpelier?
That would be a qualification that is governed by 17 VSA Chapter 43. So that's already expressly included. That you
Okay,
have
so
to be a
that's
resident of
already dealt
Montpelier.
with. I noticed we don't say that.
Yeah.
Any more questions for Tucker right now? And then we'll go to John. John, would you like to weigh in here?
Thank you all again. Nice to see you all again. I'll just, I know most of you all, not all of you all, have heard me go around on this one a couple times. So I'll just go through very quickly the thinking of the folks in Montpelier when they overwhelmingly approved this. As long as it's on the front of my mind, I might as well mention some of the question of where you live and how that is defined. I think it's very intentional that it be the same type of qualification, the same standards that we do for any voting. It's where you consider yourself domiciled. And there's been some discussion of that. And the reason for that, and the reason why we don't have a special oath proposed or a special identification requirement is that we want those things to be the same. And quite frankly, I think if you open up, say, identification requirements or different sort of domicile definitions for one class of voter, that opens the door to continuing, if we do it for them, why don't we do it for these folks? And I think that's sort of a dangerous path to go down. So really quickly, what we were thinking, I think at its root is this idea that you can be a citizen of the city without being a citizen of the state or country. And, this is figuratively speaking. But those nature of citizenship has never been a linear thing. It's always been a bit of a web. For example, I'm a US citizen, but I'm not a citizen of Montpelier. So similarly, someone can be a citizen of Montpelier without being a citizen of the US or Vermont. So those things are not just a straight up hierarchical thing. And I think that's what we're arguing. This is also not about the state or any other town. There's no statement of an agenda or even modeling something. This is simply Montpelier deciding how Montpelier wants to govern its own affairs. And the way we see it is that it's about fairness, that these are folks who in every meaningful way are members of our community. And so we feel, these are taxpayers, property owners, they have kids in the school. So it just is the feeling of Montpelier citizens that they should have a say in Montpelier city issues. I think we've established the constitutionality of it, so I won't go over that, but we certainly we had quite a few folks in here speaking about the history of this, the constitutionality, and I'm certainly more than happy to get those folks and rally them around and get them in again if it comes to that. But I think the constitutionality question is done. I think it's worth saying that we're not going into unknown territory here. There's a lot of non-citizen voting out there, even without getting into the extraordinary amount of countries that allow national citizens to vote at the local level. In this country, non-citizen parents can vote on school board issues in Chicago and San Francisco. You've got an extraordinary number of cities, particularly in Maryland, Mount Rainier, Hyattsville, Tacoma Park, Barnesville, some others. The Tacoma Park clerk, of course, testified, and in Tacoma Park, they have been doing this for more than a generation, and it is not an issue. It's very much part of who they are. It's also worth mentioning that non-citizen voting was the norm in the early days of the US, which means that our founding fathers and their children and their grandchildren were voting alongside non-US citizens in municipal elections. They didn't have a problem with it. In fact, the non-voting rights in most states, one time or another, as many as 40, were really scuttled by constitutional amendments and statutes, mostly between 1880 and as recently as 1926, which is a period when literacy tests, poll taxes, all kinds of disenfranchised laws, restrictive residency were introduced in response to a xenophobic nativist wave across the country. Again, we're talking about only applying to Montpelier, which means that the non-citizens will use ballots especially designed not to include national, state, school questions. Central Vermont Public Safety Authority, which is chartered as a municipality, is also on our ballot. They won't be on there. There'll be two separate checklists maintained by me. It sounds like more work than I think it actually is. Undocumented immigrants will not be at risk at having their information revealed to ICE or other authorities because this doesn't apply to undocumented immigrants. Again, voter registration will work exactly the same because we don't want to create new standards. As far as votes such as TIF districts, things like that, again, these are community decisions that we think the entire community can be involved in. And the last thing I'll say, because I've run into this a few times where this notion in this conversation of somehow the conversation moving to whether out of city landowners should be allowed to vote, those two things from my viewpoint don't have anything to do with each other. The only relation they have is that they both relate broadly to how we conduct our elections. So, that's the same as saying it relates, or this relates to our 18-year-old age limit, or whether or not you can get an absentee ballot. It's like, sure, they both have to do with elections, but as policy questions, I mean, the idea that a community wanting non-citizen voting has any play or relevance to the idea of essentially giving somebody two votes. I mean, perhaps a city, perhaps Montpelier, although I'd be surprised, might actually bring that question to you. But, that's when that happens, it's a distinct policy decision, just as the question Brattleboro has brought before you in the past about 16-year-olds voting is not something that comes up as a pro or con to the non-citizen voting. So just for the purpose of saying there that I can't get my brain around how that's related. But I think that gives you the real quick rundown of where we're coming from.
Senator Clarkson? You are muted.
John, would you just be kind enough to remind us what the vote was?
Oh, I was afraid you were going to ask that. I don't have it in front of me because I got called in earlier than I expected. I was ready for 2:30. It was roughly 67%, as I recall. In fact, I think it was 66 point something because I had to have this number handy recently. So,
And this
I think the question about the non-residents actually will come up because it came up last year. And and I know that there were arguments made particularly in Grafton around the wind project, that non-residents ought to be able to vote on it because they were a legitimate part of the community. They lived in the community for half of the year. They paid property taxes. They owned property. And so they should have a right to vote because they were a real part of the community. My response to them is that if you want to be a resident and be allowed to vote in Grafton, then become a resident of Grafton and give up your residency in Florida.
Well,
I mean,
if I may, I would also simply say, if that's a decision the community makes, then you'll hear from them. And they'll make that argument on its own merits. This is a different argument, and it's a reflection of Montpelier's view of its own community.
right.
So you're saying, I just want to be clear, Jeanette's saying that they should become residents of the Grafton if they want to. John, what you're implying is that Grafton could change its own local law and allow those people to vote, right?
Well, I'm suggesting that if they want to do that, that's a completely different policy question that would come before you all. And I just don't see that it in any way, shape, or form relates to the question we have brought before you all.
Right.
Grafton, they wouldn't bring that because the people that were the residents didn't want the non-residents to vote. It was the non-residents who wanted us to tell them, give them
Right.
permission to vote. So, any questions for John? This is going to be not a slam dunk again this year, I think. Senator Clarkson, you are muted.
I caught that. John, was this voted on again, or are you coming to us with the same vote from 2 years ago?
No, this is the same. The same packet that I gave you all. The same process is just coming up again. It was reintroduced, I think, by Representative Kitzmiller. But
Right, I understand. But was it voted on again this last March?
No, this is the same.
So this is the same vote with the same request from 2 years ago.
That's correct.
You can see if you look at the bill, Allison, it says the general election of 2018.
Oh, I'm sorry, I missed that. Thank you, Marian.
So I think that to answer some of the questions that we will ask, I don't remember who it was. It was a citizenship attorney who came in and testified to us last year about the process of becoming a citizen.
What
What
could
it
it have been
takes.
Dan Richardson? Would Dan Richardson have done that?
It may have been. I thought it was
Because she's
also a woman who came. But we'll follow up with them so that we get all of that information. Because those are going to be questions. John?
If I may add also, I do think there is a bit of a distinction between those questions too. Whether or not, I mean, this sort of suggestion that, well, why don't they just become a citizen?
Right.
I know the argument is that takes a long time. I would suggest that the argument is not really relevant when you get right down to it. Again, this is about citizenship of a municipality only. If again, that citizenship question is not a linear quality that we all share. So if somebody wants to be considered a citizen of their community and is not interested in being a citizen of the country, Montpelier has no problem with that, and we don't necessarily see those issues as connected in any meaningful way.
We may not see it either, but the question will come up, and we need to, if this bill passes out of this committee and gets to the floor, whoever reports it is going to need to be able to answer every one of those questions. So, any more questions for John? Okay, did Williston Winooski was going to had the same thing on their ballot at one point. Did they pass it? Anthony,
Well,
do you know?
they did, but recently there's an issue raised because they allowed school voting as well, right? Something like that, Tucker? So theirs is different.
The city approved all resident voting. It went to House GovOps. House GovOps amended the all resident voting provision to align with Montpelier's. They actually took the definition of legal resident of the United States and incorporated it into Winooski's charter to make sure that paid elected positions would be capable of being filled by the voters, because the original charter would have allowed any resident of the city, regardless of their immigration status, to vote. And there were concerns that if you ran for office, you might not be qualified to fill the position under federal employment law unless you met the qualifications that are described in the Montpelier Charter. When the Winooski Charter went to the floor, there was discussion around the fact that the city of Winooski has its own incorporated city school district, and that the charter for the school district states expressly that the voters of the school district are the voters of the city according to the city charter. So That meant that by amending the Winooski City Charter, allowing all residents to vote on city questions and city issues, that those same voters would be capable of voting on the school district elections and school district issues. That led to debate on the floor, and the bill has been committed to House Education to determine whether there are any substantial issues either with the Common Benefits Clause or the Education Clause, and what the potential impact on statewide policy and the statewide education property tax would be if you have different qualifications for school district voting across the state. So that will be brought up next week, but if it makes it over, that's something that you will all likely have to look at.
Thank you. Any other questions or comments now about this?
Not now, but I'm sure we'll have some later.
Yeah, I think that we will try to get in Dan Richardson, and I wish I could remember I thought it was a woman attorney who was looking, but whoever, we'll have him come in, and whoever else we think might be good to educate us, because I think that we need to be educated on this.
Yeah,
This is-
well, it's coming at us in two charters. So was it a woman? Was it the from the AG's office?
No, it was a citizenship attorney. It wasn't from the AG's office. But I was going to say, I'll look at my file and see if I can find it. My file is in Montpelier and I'm here, so I guess I won't.
Oh,
We might be able to go back.
We could
In the
ask Gail.
scheduling.
We could ask Gail to look at
Yeah.
our witness list from last year.
Yeah. Do you remember the number of it last year?
I bet Tucker does.
H107,
Thank you.
I think.
Okay. All right.
I'll do some combing through the records.
Okay, thank you.
Gail.
Thank you. All right. Anything else right now? All right. Well, I'm supposed to go to, I just got an email. I asked her to email Gail, not me, because I don't look at my emails, but I guess I'm going to appropriations right now. So I'll be back. You can do what you want.
What for? What are you going there
Anthony, you're
for?
in charge.
She's going
What are
for
you going there for?
20 cannabis.
good
Okay.
luck.
Yeah. Okay. I'll be back.
Can't tear yourself away.
Oh, wait, I have to leave here first.
Oops. It's sort of magic the way people just disappear. It's sort of like, I don't know,
This is true.
space travel. Space travel. Here 1 minute, gone the next.
So I don't know whether we were going to have other guests for H151, the mausoleum, vital records, mausoleums, and columbaria, emergency health orders bill. I don't know whether we were waiting for Gail. Were we waiting for anybody else to show up for 151?
I invited Representative Leclerc, and then I just notified him again that it's been moved up, but I haven't heard back.
They must
What
be.
time was he going to come?
We had it scheduled at 3.
Oh,
They're on the floor too, so they're having all sorts of exciting conversations.
well, we could do a walkthrough without the sponsor of the bill, the reporter of the bill. That's possible. We could do that, or we could take a 10-minute break and then see if he shows up. But I don't think he's going to show up in 10 minutes anyway.
Well,
Something
10
like
minutes only puts us at 2:30.
Right, but he's not. Which he may or may not be here by then anyway. We have no idea. So you want to walk through the bill with Tucker?
Let's do it.
Sure.
We got Tucker. Let's go for the gusto.
Okay, Tucker, make this fun.
Yeah, particularly the mausoleum part.
Particularly the mausoleum part.
I will do my best. I'll bring all the gusto to this topic. H151 is an act relating to vital records, mausoleums, and columbaria and emergency health orders. It's a bit of a miscellaneous bill in that it covers several different areas of government operations and the government operations portfolio. The first section of the bill generally relates to vital records and the state's statewide registration system. There are a few substantive amendments, and then there are some deletions that will require a bit of context, but not much legal explanation. So Section 1 amends 18 VSA Section 5016, which relates to birth and death certificates and access to those, specifically access to certified copies of birth and death certificates. Language is added to subsection A to allow the state registrar to authorize the issuance of certified birth or death certificates to public agencies, as that term is defined in the Public Records Act, for official purposes. There's a conforming amendment later on in the section that clarifies that an employee of a public agency that is authorized by the state registrar can get a certified copy of a birth or death certificate. For some explanation here, the government operations committees and the General Assembly as a whole, 4 years ago, started work on the statewide registration system to have a central repository for vital records. You all worked on that. And part of that was restricting access to certified birth and death certificates. Prior to that, Vermont was virtually the only open state in the country that allowed anyone to access certified birth or death certificates.
Yeah, I remember that actually. There was talk about how, I forget who it was, but somebody from the administration came in and said that they got somebody else's birth certificate just by asking for it. You know, there was no questions asked.
Correct.
So
and in the House, so this bill has actually been passed by the House twice now. And both times the Department of Health has had people come in and talk about what happened in the past where anyone in the world could request a certified copy of these certificates. So the First Amendment that I just covered is a way to solve an issue that came up, which is that public agencies that required access to birth and death certificates for official purposes no longer could, because they were not on the list of entities or individuals that can access certified copies.
that's the spouse, child, parent, those people, right?
Yes. And so later on after that, Senator Polina, you'll notice that in the new subdivision capital C, it allows an employee of a public agency, which would be a state or municipal agency, with authorization from the registrar and the Department of Health, will be able to access this for official purposes. You'll notice one other substantive addition to the list of people who can get these certificates, that is a grandchild. So under current law, only a spouse, child, parent, sibling, grandparent, or guardian may access a certified copy of these records. This would extend that to grandchildren. Sections.
Yep. Who is the state registrar? What is that about?
The state registrar is in charge of the statewide vital records registry system. So that is an office within the Department of Health that oversees the statewide registry.
So it's not Tanya? Isn't that in her office?
The state registrar is within the Department of Health. And quick review of how that works. The Department of Health has the statewide registration system, and then it has agents that conduct all of the business. And the agents, for the most part, are the town clerks who have access to this centralized repository for vital records. And then they all have these special printers where they can print these official certified copies. And I know there was testimony two or 3 years ago when work was being done on this about how much the paper and the printers cost. And
that was a very brutal, that was a brutal set of testimonies. I mean, it just went on and on and on and on and into minutia of stuff. It was really painful.
Well, I'm sorry to cause you to relive that trauma.
No, this is nothing compared to that.
Well, we haven't had them testify yet.
So Sections 2 through 4 also deal with vital records, and they deal with a very specific issue here, which is that in multiple sections dealing with corrections, completions, or amendments of birth and death certificates, there are these subsections added during the vital records restructuring that stated that any time a correction, completion, or amendment was being done in the central repository, that notice had to be sent to the town clerk, and the town clerk would be required to replace and dispose of the records within the clerk's possession. This apparently caused, as one town clerk in the House put it, hives and agitation for those local officers who were being directed to destroy records. So here, those requirements are being struck so that the clerks will no longer be required to search for and destroy records in their possession whenever they're amended at the central statewide level. There was concern in the House. Question came up on the floor. Well, how does a town clerk know that these are being amended or corrected if these sections are being deleted? The vital records laws in the general sections require that anytime there is any change in the statewide registration system to a birth or death certificate, the town clerk will automatically be notified by the system that a change is being made.
But they won't necessarily have to do anything about it.
But they won't have to go into their vault and pull up a birth certificate and destroy it.
Right.
The next section of the bill deals with mausoleums and columbaria. Not much gusto here, except that when I was putting this together, I did find that even though mausolea and columbaria are both Latin words, that according to the Oxford English Dictionary, the plural of columbariums is columbaria, and the plural of mausoleum is mausoleums. I don't know why. So there's your fun English factoid for the day. Everything else is going to be pretty mundane.
No, you're right. It's fascinating because it is, it's an exception to a rule.
See, it's fascinating, Tucker.
I'm glad.
Senator Colomar.
Thank you, Senator Polina. Just, could you define both of those words for me, please?
Yes. So a mausoleum is a structure within a designated burial area where you can put intact human remains. A columbarium is a structure typically back in the day with drawers where you can put interred remains. So both of them are the little buildings that you see in some cemeteries where people can put human remains.
But one of them has to be intact, you said.
I think that in both you have the authority to put intact human remains, but it's just the way that they're built and structured that is the discrete difference between them. And although my grandfather did volunteer as the gravedigger for Sandusfield, Massachusetts, and did build a mausoleum for his own remains, I could not tell you what the structural difference is. So,
thank you.
So the changes here, for the most part, to give you a general idea, are shifting current requirements that whenever there is the design and construction of one of these buildings in a cemetery, under current law, you have to get approval from the state. You have to get approval from the state board of health for each step of the process. The Department of Health specifically asked that this be shifted to the local legislative body with oversight from the state. So in each instance here, you'll notice that, for example, the requirement that these only be constructed or erected with consent and approval of the State Board of Health is being shifted to the legislative body of the municipality and the local Board of Health, that the approval prior to construction come from the legislative body of the municipality. There's a technical correction in what is now subsection C, just to get rid of the term such. And a new subsection D is added. due to some concerns in the House around oversight of how these are being built, if it's being shifted to the local legislative body who might not have expertise as opposed to the State Board of Health. Section D requires that construction of a mausoleum or columbarium shall be managed and supervised by a person with experience in modern mausoleum construction and engineering. Clearly, from my earlier testimony in the walkthrough, I am not that person. Conforming amendments in section, oh, sorry, Senator Clarkson.
No, it just occurred to me that the big difference, I think, between them, Brian, is that the one is meant as a sort of a waiting place until people are buried. Particularly, they were a place where you put bodies until they were buried, but that mausoleums are in fact a burial above ground. I mean, the families have many people in a mausoleum and it's above ground and it's permanent. You're staying there. But that one is a kind of a transfer usually used in the winter until they could dig graves. I'm pretty sure that's the difference between them, but we can look it up.
So one
Tucker, have you been to Hope Cemetery?
I have not.
You should go to Hope Cemetery. It's got a lot of little mausoleums. It's in Barry.
So the columbaria is kind of like a purgatory for the dead in some ways. Kind
Well,
of a waiting station.
yeah,
Way
it's
station.
that great book about Lincoln that came out about Lincoln's son. What was it, 2 years ago?
Oh, yeah.
It was fabulous. And
Robert.
it all took place within these structure, this in the graveyard with these, and they describe the difference between the two, and I'm pretty sure that's the difference, but we can.
Okay, thank you. I appreciate that, Senator Clarkson.
On the House floor, Representative Leclerc described the difference as a hotel room versus a luxury condominium. So I don't know if that's helpful.
Well, yeah, one you own and are in for a while, and one is you're just there for a bit.
Section 5577 is amended to shift some of the responsibility for determining when a mausoleum is becoming untenable from the State Board of Health to the Department of Health generally. So that's just, again, shifting some of the responsibility around this from the state board to another agency, in this case, the Department of Health. The final section of the bill deals with emergency health orders. The amendments generally can be said are extending the avenues by which a health officer can achieve delivery or service, legal service of a health order to a person. Under current law, health orders must be delivered according to the Vermont rules of civil procedure, which would require that they either be delivered by US mail if that is possible or feasible, but typically served by a sheriff. The amendments here would allow for in-person service by a health officer to be able to achieve that. So they wouldn't have to go to the sheriff. The health officer at the local level would be competent to achieve legal service of the health order. Again, just to cover the general structure here at the local level, you have town health officers who are competent to deliver orders from the local health board to mitigate some sort of health risk within the municipality. And those are either executed through authority of the Department of Health or through local ordinances that are adopted with approval of the Department of Health. But from what I understand, this is something that is being done right now, or at least it was done in the spring around COVID, was the issuance of emergency health orders. Finally, there are some repeals here. Both of them somewhat conforming repeals based on the previous sections of the bill. First, 18 VSA section 5574 is repealed. This required the State Board of Health to inspect mausoleums and columbaria, again, with the authority being shifted to the local legislative body. The local legislative body would have to approve first that these were going to be built, then approve the design, then approve the construction. So that section was thought to be somewhat unnecessary as it related to the State Board of Health. Second, 24 VSA section 2654 is being repealed. This is actually somewhat unique and on its own outside of the rest of the bill. This was a result of discussions in House GovOps 2 years ago when this bill first came up. Maybe it was only a year and a half ago, that under current law, under that statute, anytime there is an emergency service district and the Department of Health has approved the formation of that district, that a copy of that determination has to be preserved by the Secretary of State. It's already being preserved by the department. It's being preserved by VSARA. So VSARA said this statute is duplicative and unnecessary and should be repealed.
Well, I have to ask, what are emergency service districts?
So under general law, multiple municipalities with approval of the Department of Health can form a district for the purpose of providing emergency services.
Okay.
And from what I recall, there are not many, perhaps, that have gone through the specific process of getting authority, but one that is maybe even chartered is the one that Paco Omand represents, and I think that you all heard from, and is that Barry is part of that, and they deal with dispatching services.
Wasn't it Barry, Berlin, and Montpelier?
Yeah, I know what you mean. It's called something else, but that's what you're talking about. Yes. Public something authority.
Central Vermont in title, no?
Yeah.
Public safety, something, I don't know.
Yeah, it's public safety is in the title. I forget exactly what the title is.
And he's subsequently left, I think.
Yeah. Anybody else got questions for Tucker on this bill? And as far as I know, there's nothing else on the agenda for today. So what I'm going to suggest that we take a 10-minute break. And so when we come back, we'll see if Rob Leclerc is here, because that'll be getting close to 3 o'clock by then. And then if he's not coming, we'll call it a deal. But maybe Jeanette will be back by then as well. We can talk about what we're going to do next. But I would say there's no sense of us sitting here waiting for Rob Leclerc. So we take a 10-minute break. Does that make sense? And come back and we'll see where we're at in terms of Jeanette and also Rob Leclerc.
So we come back at 10 of or 5 of? It's a little in between.
I would say 5 of.
Okay, great.
Okay. Oh, Jeanette. We went through the bill about the mausoleums and whatnot. And we finished that, and we were waiting for Rob Leclerc. We did it with Tucker. Rob Leclerc has not come up yet. So we were going to take a little break and then see if Rob Leclerc shows up at the end of the break. Because by the end of the break, we'll be close to 3 o'clock. Unless you have something else we need to do, because there's nothing else on the agenda.
No, do you want to hear about
Yes,
whether we
definitely.
got the money for the the cannabis business development loan fund?
We got that. Great.
And
How much?
and there was a debate about whether they should take it out of the general fund and then in anticipation of paying it back to the general fund when the revenues start coming in. And they decided not to do that, but just to put it in from the general fund, and it'll just be there. And then if it is a revolving loan fund, it'll keep revolving, and then the money will be coming in potentially from the dispensaries. So it could have another 250,000 in there within the year of opening, but it'll stay there and it doesn't have to be paid back. Huh?
The initial amount that they're putting in is 250?
5.
5, wow, that's great. They must have been in a pretty generous mood today.
Well, that's what we put in the bill. That's what you put in on the day.
Yeah, but I didn't know that's what they were going to go along with it.
Well, they did.
That's great. You must be I wish you'd come in with me on all my bills. You do really well. How did your 2% fare in the in finance?
Oh, I don't know. They have all these, everybody has a different idea. Well, maybe we could have a local option tax of 2%. That doesn't do anything. And that's on top of the price. We don't want to increase the price of the product anymore because then it defeats the purpose of getting rid of the underground market. I mean,
Right.
if you keep adding costs to it, it's just not going to work. So I don't know what happened.
Sharing in the excise tax is the way to go. I think that's what your proposal is, isn't it?
Yeah, that's what the proposal is, to get rid of the state imposed fees because they're just one time and they don't do anything for the municipalities at all. And that also adds to the cost of the product. And, you know, and people keep saying, but it isn't the consumer that's paying, it's the licensee. Well, the licensee has to make up their costs. So of course they're going to pass it on to the consumer. But anyway, we got that and we'll see what happens with the 2%. I don't know. They also thought that perhaps they could, if they didn't have time to do it, they could add it someplace else. I don't remember where. So, okay. But anyway, we got that one.
Good.
Okay. So we're taking a break till 3.
Yes, and then we'll see if Rob Leclerc shows up. I don't know whether Tucker, you need to stick around or not. I mean, if you want to, obviously you're always welcome, but
Look, he's there. It's magic.
So what time was this scheduled to be on?
3 o'clock.
Okay, because there was somebody else who wanted to join us. His name is Joshua Green. He's a naturopath, and he thought this might be the place to add the question about
Green funerals.
no,
We have
about he's a naturopath. Right now, a naturopath apparently isn't qualified to determine whether somebody is dead or not.
Okay.
So they're not allowed to sign death certificates. And for whatever reason. So it's an issue with the Department of Health and OPR, but this might be the place to address it.
Madam Chair, would you like me to invite him for 3 o'clock when we come back?
Oh yeah, I thought I sent you a note to invite him today.
No.
Oh, you know, I start these notes and then if I don't push send right away. I did that to Senator Collmore this morning. I was very bad. But anyway.
Well, he weighed in while we were conferring, so I will send him an invitation right now.
Okay, thank you.
So we're on break till 3.
Okay, thanks. Yep.
Thanks.
Thank you.
Allison, I'm going to call you.
Me?